Good morning. Welcome to Newsmakers. Voters in the state of Ohio this fall will determine the fate of two statewide issues. Probably the most important and certainly the most controversial is Issue 2, the reform of the state's workers' compensation system. Although we will focus this morning on the political and legal aspects surrounding Issue 2, ultimately the outcome will affect individuals in their everyday lives. I'd like to begin this morning by introducing you to two local women who will be affected by the changed system.
Workers' comp has been a prime issue for us as a manufacturing facility and primarily a trucking company.
Harrison Concrete, which is family owned, does about $5 million of business annually and pays about $100,000 in workman's comp premiums each year.
In addition to the premiums you're paying, you're also contracting with third-party administrators to represent you as an employer to try to facilitate this maze of paperwork that's existed,
bringing the total to $150,000 a year.
But what we're saying is that there has been so many abuses within the system, and the way the system is set up is that the claims can be extended for so many years that it becomes almost a social welfare program more than a medical insurance. Just like any other system, the more efficient you make it, there will be cost savings. We're hoping to keep it under control.
When I started at UC in 1978, there were no computers per se. There was microfiche readers, and you had the ability to do different tasks at different workstations. In the mid-'80s, the PC came on board, and you were stuck, so to say, at the PC. And that's what happened to me. I picked something up wrong, and I really messed, and it scared me. And I thought, if I don't get a workman's comp claim, not to get money, but just to be assured that on down the line, 20 years from now, I won't have some help if I happen to lose the ability to pick up and grasp.
But under the revised system, it will be much more difficult for injured workers to prove that diseases like carpal tunnel are work-related and not the result of activities like sewing or playing the piano at home.
The question you ask, or the question I ask, is why would they want to change the routine in which employees can file for workman's comp? The conclusion that I come up with is that there are so many carpal tunnel injuries that it is flooding the workers' comp system.
To discuss the implications of Issue 2, I am joined this morning by two people. Roger Geiger is the Executive Director of the National Federation of Independent Business, Ohio, and the Treasurer of Keep Ohio Working, the organization formed to pass Issue 2. Greg Claycomb is an attorney with the Cincinnati firm of Kircher, Robinson, Newman, and Welch, and he represents workers with claims before the Workers' Compensation Board. Earlier in his career, Greg worked for industry and saw the system from the other side. Welcome to Newsmakers.
Good morning. Thank you.
One thing I think we should begin by saying is Issue 2 and Senate Bill 45 are really sort of the same thing. The Senate passed, or the legislature passed, and the governor signed what is called Senate Bill 45, the reform of the system, and then through referendum, this is now on the ballot and being reviewed. So a yes vote would be a vote for the new system, and a no vote is to go back to the previous system before Issue 2, before Senate Bill 45. So we may mix those terms. I wanted to clarify that right from the beginning. Roger, just to get started here, the assumption by those who support Issue 2, Senate Bill 45, is that there were abuses, that the system had become tilted too much in one direction. What can you point to indicate that that in fact was the case? And give me one or two examples of how this new system will change that.
Well, I think it's important to understand that Senate Bill 45 and what the voters will be voting on is a part of a reform system that began 6 years ago. When the governor first was elected, He referred to our workers' compensation system as a silent job killer in the state, and without question it was. And particularly for the constituency that I represent, small businesses, it was particularly difficult. Surveys that we've done of our 36,000 small business owners across the state show that the cost of workers' compensation, the frustration with compensation, ranks as their third highest priority out of a list of 75 business issues. So it is a very real issue for Ohio's small employers in particular. That process began 6 years ago. There were two other pieces of legislation that dealt with two other parts of the workers' comp system. We've clearly seen dramatic changes as a result of those reforms, and this reform is kind of the third leg in the stool, if you will. You've got to have it to really make the sweeping kinds of reforms that we so desperately need in our system.
Now, when you say this was a very high priority for small, moderate-sized business, those businesses found it burdensome. But you're going beyond that. You're saying that the system was actually unfair and riddled with fraud, too. Am I correct?
There's no question that we have had historically a system that has not worked both for injured workers or for employers. And I might add, at least in my opinion, those are the only two primary stakeholders in the system. The people who need it to be legitimately compensated for legitimate injuries, to get the medical care they need, to get the kinds of assistance that they need temporarily until they're able to come back to work. And the second is the people who are paying the tab. Employers in this state pay almost $2 billion in the premium tax to the state of Ohio to run that system, and I think it's not unrealistic or unfair to say that they expect that system to be efficiently and well managed. And without question, historically it has not. And I think a lot of that isn't. There's been fraud, there's been abuse. I mean, $167 million of fraud have been identified since up through 1986. That's what's been identified. It's not just issues of direct fraud, but because the system has become so complex, so cumbersome, so bureaucratic, it has led to either intentional abuses or unintended abuses that have helped neither the employer or the injured worker get through the system the way they should.
Greg, Roger's just laid out his view of this. Would you say, from your perspective, that the system as it has existed up until this point, was tilted unfairly against a business and riddled with fraud and all these inefficiency problems? Would you say that, in fact, there was a need for reform, and maybe you just disagree with this particular reform?
I agree with Roger that there was a need for reform, and there have been reforms made over time. I would note for you, however, that this latest piece of legislation, what is issue 2 before the voters this fall, actually has gone too far, inasmuch as there are not only some minor provisions that do attempt to address fraud, and only from, in my point of view, the worker's side, not the employer's side, but does take away essential benefits that have existed traditionally for injured workers in this state. And by taking away at least 5 particular benefits that I've identified myself, I believe that we're really emasculating the entire system, and we're going to put a lot of workers, shifting them from workers' compensation benefits to welfare benefits, which in turn burdens all of us as taxpayers. So reform is necessary, and if this was the sole purpose of this bill, I'd be all in favor of it, but that's not the sole purpose.
What's the purpose in your mind?
In my mind, the purpose is to take away benefits and to save or to give tax breaks to employers, premium breaks, to the tune of about $200 million a year, and on throughout the future, increasing those returns to employers.
Okay. Let's take it.
Can I just quickly respond?
Quickly.
First of all, I take exception to the idea that creating felony convictions for providers and for employers is something brand new in the system, is somehow all tilted in the side of claimants. When you create brand new criminal penalties for employers, and we support those. I mean, we're not interested. So there are very tough fraud provisions that have been embodied in this bill. I might also add
fraud provisions that cut both ways.
Yeah,
you would
absolutely.
argue?
I mean, we've had fraud provisions historically for claimants. We have created a whole new set of statutes, and hardly something that we, jumped up and down and asked for. So I think it shows some of the balance in the legislation created very stiff penalties for medical providers and for employers who cheat the system by not appropriately reporting, for example, what they owe to the Bureau. And so there's been some very significant new changes that are directly geared at employer and provider fraud. The second thing I'd make an observation is that these reforms, the same folks that said that the reforms of 1991 and the reforms of 1994 were terrible and we're emasculating the system, are now turning around and saying that those reforms have actually helped and they've improved the system. Well, they have, and this is clearly a step in that direction to continue those reforms. And the last observation that I'd point out is that the $200 million, I'm not sure where he gets that figure, because the Independent Legislative Budget Office estimates that to be more like $100 million. And again, when you say $100 million, let me just, to somehow suggest that that's out of a $2 billion system, we're not emasculating the system. We're trying to get at those root causes that really where there is fraud, but it is really driving the system.
Let me try to get this down to some, we're up here dealing with lots of huge numbers and big theories here. Let's take a couple of cases. And Greg, let me just give you a case, and you tell me how this case would be different if it came on your desk 2 years ago versus how it will be if it comes on if issue 1 passes. A worker, 59 years old, he's got a high school education, he's a construction worker, hurts his back, serious back injury, can't any longer lift heavy objects, therefore can't do his job. How is that person going to be affected? How would it be different from 2 years ago versus 2 years in the future?
Many different aspects of the current legislation that is in effect right now protects the worker. This new bill will take away benefits such as ongoing working wage loss or wage loss. We've reduced, or this legislation attempts to reduce, wage loss benefits from 200 weeks, almost 4 years, down to 26 weeks, which is a half a year. That would certainly affect this individual should he return to another job that is lesser paying. Let me take you back for a moment and explain that wage loss was a creature that was created back in 1986 in an agreement between labor and business to try and recognize that when somebody gets hurt on the job and can't go back to that former position of employment, that they're undoubtedly going to take a loss of wages or take a position where there's going to be reduced income. So it was considered that approximately 4 years would put that injured worker back to where he was at the time of injury. Now that never actually occurs, but by reducing that benefit from 200 weeks down to 26 weeks, most people don't get raises after 26 weeks, let alone a year. So obviously that's a major impact upon an injured worker. But in your instance, if this individual is never able to return to work, and at age 59 he's beyond the Industrial Commission's guidelines for rehabilitation, he will not be able to go through a rehabilitation program paid for by the Bureau of Workers' Compensation or the Industrial Commission. So now he is confronted with, what am I going to do with the rest of my life? Under the proposed legislation, consideration of his vocational background, if he was merely a laborer all of his life, and also his education, maybe a high school education, maybe not, those don't come up any longer. Sociological factors are also considered currently. In other words, where was the education obtained? Was it obtained at a public school here in Cincinnati or in the hollows of eastern Kentucky? That's an important consideration. The reason I say that, Dan, is this. If this worker under the current system is able to obtain permanent total disability benefits, he will be protected for the rest of his life. Under the proposed system, it will be permanent total impairment based solely upon his age and the allowed conditions in his claim. The consideration of those non-medical disability factors is impermissible under this new legislation, and he will in all likelihood be denied benefits because they will say, the Industrial Commission will find that this individual could do some type of sit-down job when he's never had any experience in that area.
Okay, Roger, what do you say about that?
Let me respond in a couple ways and try to set the record straight, at least from my perspective. There's a confusion here, and it's a very interesting way that the blurring of non-working wage and working wage lots was so cleverly just done. Working wage lots, that which you would get while you're off work, or the differential between if you went to a lesser paying job, would be compensated and is not changed whatsoever under this law. What is changed is non-working wage loss, which is when you've received all of your benefits and you have been released to go back to work and you can't find work for whatever reason. It's really an unemployment issue at that point, not a workers' comp issue at that point. You've received your temporary benefits, you've received your medical benefits, you've received your working wage loss benefits, you've received your permanent benefits, you've received your medical benefits. All of those benefits have not been changed at all in this bill. The one benefit has been changed is an unemployment benefit called non-working wage loss. And we had a system in Ohio that was out of whack with every other state in the union. We allowed you to basically collect unemployment for up to 4 years, 200 weeks, up to $521 a week, tax-free. It's a very rich benefit. Kentucky and Indiana don't even have it. Michigan doesn't have it. I think it's very important. It's very confusing. I recognize when you get into these terminologies that it's very confusing, but to somehow suggest that somebody would only get compensated for all their wages lost for only up to 26 weeks, which, by the way, there's also a provision that allows it to go to 52 weeks in economic downtimes. I think you have to be very careful you understand the differences of those provisions.
Well, I think this reveals some of the complexity of this issue, and unfortunately, I've got to take a break right now, but stay right there. Be sure to stay tuned. After the break, we will discuss the impact of Issue 2 and the role of attorneys in the new and old systems. We're going to come back to...
Here's the choice you have on workers' comp, Issue 2. Wait for a check because the law says you have to, or vote yes and eliminate the delays. Use a lawyer who takes a third, or vote yes and keep the money for your own family.
In a nutshell, Issue 2 makes it a lot easier for injured working men and women to get the benefits that they're entitled to without having to hire a lawyer. When injured people in this state are injured, they need a doctor, not a lawyer, and the old system meant they had to see almost a lawyer first in order to get the services that they needed.
I don't know that I would have the legalese to go into a workman's comp room faced with the person who makes the decision, the individual who is a representative of the business, and their attorney, and just plead my case. And I believe you're going to have to be seen by their doctor. So here's a whole lot of people on one side of the table, and here you sit on the other side. Just by sheer volume of people in the room, I would feel intimidated. So why they would say you wouldn't need a lawyer, I have no idea where they're coming from. Welcome back.
Roger, has this campaign turned into attorney bashing because attorneys aren't very popular out there in the society as a whole?
Well, and with a tremendous amount of respect for the person sitting to my left here, I think it's important to understand that this is a no-fault system. This should not be run. It is unfair that we spend about $200 million a year that claimants should be receiving going to lawyers in a no-fault system. This is not like a civil trial where you're trying to assess blame, you're trying to assess a percentage of fault. In our workers' comp system was intended, and that's why we have a government-run system, was to simply to make that efficient and effective for the injured worker to get through. And the reason that they've often historically had to get lawyers, and this is not lawyer bashing, because the system has been so complex, so cumbersome, so litigious, the definitions have been so difficult to work through, that yes, both sides have needed lawyers. But in a no-fault system, that shouldn't be the case. That should be the exception to the rule and not the general rule. And so I think it is fair to say that not to lawyer bash, but I think it is very fair to raise the issue of how much money is being siphoned off of the system in legal fees and not going to claimants in a system that really wasn't designed to have to do that.
Greg, you heard Connie Boyce from UC saying that, gee, she didn't like the idea of going into a room, sitting across the table from the government officials, the business officials, and they're backed up by their lawyers without a lawyer. Will the injured worker just not need folks like you anymore in this new system?
No, actually, Dan, I think what's going to happen is that more people are going to be coming to my office for assistance than ever before. The reason I say that is simply this. There has also been the advent of managed care in workers' comp, and that began earlier this year. That is where, instead of the Bureau managing the claims, that actually third-party outlets are now handling or processing the claims, and they're very confused with the system. There's an incredible amount of difficulty with this MCO system, and as a result, injured workers have been coming in greater numbers than ever before. But to address one thing that Roger pointed out, this system does not really encourage attorneys to get involved. I don't know of any attorney that's ever gone to a hospital, for example, to solicit a client or claimant in the workers' compensation system, but the Bureau, in a memorandum dated August 4th, 1997, noted that of all the claims filed in 1995, only 13% of those were those injured workers were represented by attorneys, and in 1996, only 12% of the injured workers were represented by attorneys. The percentage of allowances versus disallowances of the claim were almost identical. So attorneys are necessary in this system to help the tougher claims get through. That's what we're there for. Not in every instance, and I agree with Roger, not in every instance should an attorney be involved. But employers will always have their attorneys at a hearing. I think an injured worker should be entitled to the same representation.
First of all, I think managed care is a different debate. I find it interesting.
But related.
But related, obviously, but to the workers' comp, and it was clearly part of the reform. And we say, oh, it's so terrible, but yet Ohio is one of only 6 states that have a monopolistic system. That means that we see private sector managed care operations existing in 44 other states, and we don't see the sky falling apart. In fact, we see them doing it much better than we do. The second thing, the same memorandum that he refers to from the Bureau also goes out to point out that, yes, most claims are medical-only claims, about 80% of the claims which are for less than $1,000, and I don't know very many lawyers that are going to get involved in a claim that's only worth $1,000 or less. You got to look at the claims that really drive the system, and there's about 500,000 of those, the wage loss claims. And if you look at the active claims of those that really drive the system, that number is 62% that are represented by lawyers. Let me just say that when the woman that you had on your tape indicated that there'd be this minion of lawyers, there shouldn't be a minion of lawyers for either employers. We shouldn't have to absorb that cost as employers, and neither should the injured worker. That's what we have, a government-run system. We've elected to do that. The voters have upheld that through a constitutional amendment to uphold a government-run system.
I want to move on because we're going to run out of time. One of the key issues in this has been the redefinition of certain types of injuries. Carpal tunnel, for example, that you now, under the new system, would have to prove that is peculiar to a particular type of job and not contracted someplace else. And in that first piece, Connie raised the question of, why are they making this change when we're going to a computer-based society to make it so difficult? And very quickly, because we're going to be running out of time, why is that change being made?
Well, again, I think this is an example of a good scare by the other side when they're making this claim that carpal tunnel syndrome will not be covered. In fact, the new definition of what constitutes an occupational disease, which by everybody's definition agreed that it was unworkable, confusing, and didn't make any sense, and invited all kinds of abuse and litigation. The new definition very specifically in it says that there are exemptions for repetitive injuries and cumulative trauma injuries.
So you're saying that it won't be more difficult?
What you'll have to do, like any other occupational disease, is show a direct relationship to your employment. That's what workers' comp is for. That workers' comp is you have to show medically that there's a direct cause to your workplace environment that caused you to have that injury. And I don't think that's unrealistic to expect in a workers' comp system that's designed not to take care of other issues, but to take care of workers' comp issues.
Greg, is it that benign?
No, it is not. It's going to be much more difficult because examples where if, especially women, this legislation does target women in this regard. If you have diabetes, if you have a thyroid problem, any sort of hormone therapy, those sort of things, if that can be pointed to as at least in part the cause of the carpal tunnel, perhaps a minor contributing factor, the claim will not be allowed for carpal tunnel. So although you can point to doing 8 years of repetitive work at a keyboard for 40 hours a week, if you can point to any one of those other factors, what was once a compensable claim now becomes a dead claim, a denied claim. And that's not fair. And that will target women more so than men.
We've got about 30 seconds to go.
I just have to strongly disagree with that. I encourage people to look at the specific exemption in the bill that's there and educate yourself on it. It does not target women. That is just really a very unfair criticism.
Well, we're going to be running out of time. Let me point out there's lots of literature out there that can be looked at. An easy place to start is this little pamphlet that's put out by the Secretary of State and is available through public libraries. So you might want to pick that up. So thank you for being with us, and join us again next Sunday when we'll take another look at another election race and also talk to a tri-stater who saw how much people deprived of democracy for generations will do when offered the chance to vote. Thanks for being with us.